All right, so the first thing we have, the defense is requesting return of property.
That one I think we talked about.
We talked about that, I believe, that's the van.
It's the van. It's
after sentencing judge, the state would not approve that.
Okay. All right, so are you then asking that the motion for return of property be continued until February 13th?
Yes, that's fine, Your Honor. We're here for today on a motion to reduce bond.
Right. We go one thing at a time.
I'm sorry, I didn't know this before the court, and I have a copy here.
So first things first, the motion of return of property, you're asking that be continued to February 13th?
Okay, pause right there. This is one of those procedural moments that might seem small, but it's huge. Sentencing is postponed, bond is still active, and that means the defendant is in legal limbo. Not convicted yet, but not free either. And when bond becomes the battlefield before sentencing, that tells you one thing: stakes are high, and someone's worried he might not stick around.
That's fine with me, Your Honor, unless the court wants to sign an order post-dating it until after sentencing.
Oh, I don't post-date.
I understand.
All right.
Yes, we're fine with continuing that.
All right, and then the next thing we have is a motion to reduce bond. State, have you had a chance to review the request for a motion to reduce bond?
No, but we're aware of, we've talked to the defense counsel about what he's asking, and actually I'm reviewing it right now, Your Honor. We gave you a copy.
All right.
So yes, we're prepared to go forward.
All right, defense?
Your Honor, we have a witness we would like to call on support of the motion.
All right, if you'll call your witness.
Are we going to call you that, Teller?
Sorry, Yvette.
Teller. T-E-L-L.
All right, and you'll need to, I think.
Now this is where context matters. Failure to stop and render aid is already serious under Texas law, especially when it results in death. But when the defendant also has another pending felony, that affects how a judge views risk. Is this a tragic accident, or part of a larger pattern? Judges don't sentence in a vacuum, they look at the full picture.
What do you want him to step?
Mr. Teao, welcome to the side.
Good morning. If you could raise your right hand for me. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, I'm going to need you to keep your voice up so that I can hear you and the court reporter can hear you. All right, defense?
Thank you, Your Honor. Yvette, would you please identify yourself and your relation to Michael?
I'm Michael's older sister.
Okay. And you're aware as to the charges that are against him? Is that right?
Yes.
And you're aware that he has already entered into a plea?
Yes.
Okay. And are you aware that he is set for sentencing next week?
Yes.
Why we are here is because we have a motion before the court requesting that they reduce his bond amount. Are you aware that there has been a bond in place on this case for almost a year?
Yes.
Okay, and you're aware that the amount on that is, I believe, $70,000? As Michael's sister, have you been able to be in contact with the rest of Michael's family?
Yes.
Okay, and have y'all attempted to raise the funds to post that bond?
Yes.
Okay, have y'all been successful?
No.
Okay. Do you want to have the court reconsider the bond amount?
I do.
Okay, and could you tell us why?
Michael has two daughters. He's divorced, his wife remarried, and had more children. Last year, one of her babies died. At 9 months old, it was a twin baby, suffocated. My sister-in-law's doing okay, but obviously struggling, suffering. His oldest daughter's 18, his youngest is 13, just hitting puberty. There's a lot going on emotionally with them. He's always been a very involved father, very active father. Again, we understand what's going on with the court, but we asked if there's any way you could reconsider, just so he could spend a little bit of time with his girl. It would be important.
If Michael were to be released, do you know where he would stay?
Yeah, he would stay at one of my houses. One of my aunts lives there. She's elderly. She's 80 years old. It's a big house. It's enough room for him to be there to stay with his daughters, to see my father. My father's 73. If he ends up doing, well, he's 10 years. My father will be 83. God willing, he'll still be alive, but there's no guarantee with that either. So it would be enough room for him to be able to visit and just take care of any affairs that we need to put in place with his daughters and with my father.
Okay. And with Michael being able to stay at your house, would you be willing to assure the court that you would assist in making sure that Michael does everything he's supposed to and appears back in courts on Monday?
Yes, absolutely.
Okay, we'll pass the witness.
All right, state.
Yes, Your Honor. Ma'am, are you aware of why your brother's bond was increased?
I'm not so.
Would it be surprising to you that he failed to appear to court?
Oh, no.
That doesn't surprise you?
Well, no, because I know that he will not come to court.
He didn't come to court.
Yeah.
And so why would the judge reduce it from the current bond if he didn't fail to show?
Because one, I'm asking for the judge to reconsider it, but you're asking me why. That's why I don't. They're saying that if he didn't show up, if I knew that, I do know that. I know he didn't show up.
For over a year.
Yeah. And at that point, sir, I was not the person responsible for making sure that he was here.
But now you are.
Well, I'm willing to be.
Okay. You stated that y'all try to raise funds as a family. What did y'all try to do?
Well, had to consider, and not trying to just go into our savings, being able to see what we could put together. My father did consider pulling money out of his 401k, but we did have to pay attorney fees as well. So we had to decide where that money would go, and that's where it went.
So you do have savings that could be used for a bond loan?
We do, but not enough to cover I guess right now they're asking for $70,000, so we don't have that.
The bondsman's not asking for $70,000. It's a portion of that.
A portion, correct.
How much is that portion? Have you talked to any bondsmen?
We have. I don't have anything written down in front of me, but yes, we have.
How many?
I don't know, so I couldn't tell you. I honestly couldn't tell you, but there have been more than one. Obviously, we checked before. He had the other charges that he had, and those are not there anymore. So,
and there it is. The prosecution just dropped the bomb. He already failed to appear. In bond hearings, this is the cardinal sin. Because bond isn't about punishment, it's about trust. Show up to court, follow the rules. When someone skips out for over a year, that makes reducing bond a very tough sell. So now the sister isn't just asking for mercy, she's asking the judge to gamble.
They've changed. Everything has changed. But if you want to know, have we called people? Absolutely have. We were actually asked to wait until there was the hearing, the bond reduction hearing, and they asked that it's on record, so they said that we should wait till that was over and then to call back. And that one was Gabriel's bill's bond that we filed.
You stated something about other cases were taken care of that were also pending. What cases are you speaking of?
I don't know, sir. It was cases that they told us on the phone. They said that everything needs to be cleared out in court when we had to come here so everything could be cleared out.
So cases that were, in a sense, taken into consideration for a plea on this case. Are you aware of that?
Yes.
Okay. And you said several houses. You stated several houses. Do you have several houses?
I don't have several. I have more than one.
More than one. Okay. Did you ever look into maybe taking a mortgage out or anything like that, or bond against that to get your brother out of jail for the 1 week? No? Okay. No further questions, Ron.
Any further questions?
Just a few. Yvette, when you're talking about these other cases, is it possible that you could be talking about this same failure to stop Miranda raid because it was dismissed and re-indicted multiple times?
Yes, and I don't quite understand all of it. I don't understand how it was dismissed, and then this is not my area of specialty is that, so I don't know exactly what happened, but I know that there's been a lot that's happened with this,
right.
So I don't know.
And we had We had filed a motion to reduce bond, I believe, back in September of last year. And I think that's when we had tried, is that when you had tried to contact these bondsmen and try and arrange everything?
At that point, I think my father was the one who had done that. I did not do that. This time around was when I had some people help me to call around. Just again, I don't quite understand all of it, and they did so.
Okay. No further questions for this one.
All right, thank you so much for coming in. All right, any other witnesses?
At this point, we would like to call Michael Teao to testify and answer a few questions.
All right, can you raise your right hand for me, please?
Yes, Your
Do
Honor.
you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand, state your name for the record. Please keep your voice up. And everyone in the box, you're gonna have to either whisper or stop talking.
Michael Teao.
All right, defense.
Thank you, Your Honor. Michael, you've been in continuous custody for about 284 days, is that right?
Yes, sir.
Okay. And were you living in a house prior to your arrest?
Yes, sir.
Okay.
Everybody was hoping I could come home. I could pick up my property. But other than that, I had to move from there, bring the big kid.
Okay. Would being out for this short amount of time, would that allow you to take care of some things that have been building up for you while you've been awaiting the resolution of this case?
Yes, sir.
Okay. And you do understand that you have already entered into a plea agreement?
Yes, sir. I'm taking that.
Do you understand that if the judge were to grant the motion and to reduce your bond and to allow you to go out, if you were to not show up on Monday, that the judge would not have to honor that plea agreement?
Yes, I understand that, sir.
Okay. And do you understand that that is a likely fear in the court and from the state because of the fact that you have failed to appear before?
Yes, sir. I understand that.
Is there anything that you would like to say to the court to address that?
I made one bad decision after another. I can honestly say that this time being in for the continuous 284 days, that I don't want to violate the agreement that I've come to. Me and the state and my attorney have come to an agreement, and I feel like it's my responsibility to go ahead and fulfill that agreement. So I don't want to violate it, and I just want to get this done with. Get on with my life now.
Okay. And what other things would you be able to take care of if you had the ability to be out on bond?
As of right now, I've asked my sister and my father to see if they could help me with my VA benefits, but because it's not me, they can do it for me. This is something that I will be able to approach and handle firsthand if I was released job. So, I mean, that's one thing other than having to do with my kids.
Okay. We'll pass the witness.
All right. Any other witnesses?
No further witnesses, just argument.
All right, Mr. Teao, what I can tell you is with regards to the VA, I mean, there are good things about it, of course, but it works very slowly. And I don't see anything being accomplished in a week with the VA. Your motion for bond reduction is denied. Counsel, would you prefer to go ahead with sentencing now, or you want to come back on the 13th?
I think we'd like to come back on the 13th, just I think the main issue was the victim statement.
Yes, Your Honor, the victim's family would like to be present after everything.
Okay, all right. And your client's in the middle, if you can. Court is calling 2022 CR 8111, State of Texas versus Michael Teao. Can I have parties announced for the record for the state?
Jason Dorkins for the state.
For the defense?
I'm going to campaign for the defense.
And are you Mr. Teao?
Yes, Your Honor.
All right. You entered a plea on January 17th to count 1. You entered a plea of guilty. The court found there was sufficient evidence to find you guilty. Count 2 was waived without objection, and so was the enhancement. According to the plea bargain agreement, punishments be assessed at 10 years in the prison. Are both parties ready to proceed? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Defense, anything you wish to say on behalf of your client?
We would ask the court to allow Mr. Teao allocution, and then we have one.
All right. You want to raise your right hand? Do You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Michael Teao.
All right, what would you like to say?
To begin with, my condolences, my most respect to the family.
Denial. And legally, that makes sense. Judges weigh community safety, flight risk, and past behavior. With a prior failure to appear and a plea already entered, the court isn't rolling the dice. Notice something else. The judge even comments that the VA process moves slowly. Translation: I'm not convinced a week out changes anything. Cold, procedural, but methodical.
I'm with Mr. Newman. I'm guilty. I failed to render aid. I can replay the incident in my head a million times. I kind of wish I didn't get up, or maybe I drove faster, slower. I'm sorry. I apologize to the family. I'm not a bad person. I just made a bad decision that day, and I understand that I have to take responsibility for my action. That's it, man.
All right, thank you.
Your Honor, we would just have argument. The defendant is charged under the failure to stop or render aid statute resulting in death. It is counsel's belief that the legislative intent behind that statute was not particularly to govern a situation that happened in this case. Back on the 1st of July of 2019, this was during the construction that was still going on, that was heavily around the 151 and 410 interchange south of Petrenko. And because of all that construction, the various entrances...
That's allocution. The defendant's final personal statement before sentencing. No cross-examination. No interruption. Just remorse, at least in theory. And here's the uncomfortable question. When someone says, I'm not a bad person, I made a bad decision, does that matter to you? Or does leaving the scene erase everything else? Because legally, intent for the crash may not define the sentence, but leaving absolutely does.
And exits to the highways were closed, and people were forced to take, instead of a turnaround, go through a light and come back around. And it was at the intersection where the turnaround was closed that the incident took place. And unfortunately, given the circumstances, this was in the saddest way to express this, an accident. There was no mens rea or mental culpability by Michael involving this, except for leaving the scene and being an individual who failed to stop and give assistance. According to the evidence, and from what I've seen, the first person on the scene, who was an individual behind the decedents, was a woman who had been a nurse for over 20 years, I believe. And she was immediately on scene and was able to provide whatever medical measures were necessary. This was a highly trafficked area, and due to the city statutes and city laws and requirements, there was off-duty law enforcement around the scene because there was construction going on. That's required by the municipal code. And so there were multiple individuals that were immediately there, present around the scene, and that could have administered far superior aid than Mr. Teao could have on the date in question. And I don't believe that there is anything that Michael could have done that would have changed the outcome that happened to, unfortunately, that happened to Mr. Neal. I think that even though Mr.